Yeah.
Okay, so now we start with the second part of our issue. So we would like to ask to the applicants some questions, and I leave the floor to my colleague.
Hi, dear applicant. A question for you. Uh, how do you justify the affirmation in paragraph 184 where you say that BH was legally independent and autonomously determined the course of action on those markets? 184.
Yeah, I'm reading it. How do I justify the claim? Uh, Your Excellencies, we would like to take time to answer it in the next hearing.
Okay, you can ask tomorrow. You can answer tomorrow.
Yeah, thank you.
The next question is also for the applicants.
I'm so sorry. Okay.
Uh, can you explain why BEG is not present in the five markets? If I understand you correctly.
Dear Judge, I would like to answer the next hearing. Okay. What was the question?
Why BEG is not presented in the five markets?
It's not
Number E.
Okay. Okay. Thank you.
Do the defendants have something to say about these two questions? About these two questions, one of the two or both?
Thank you, Madam President. We would just submit that bank is actually present on the markets as we have submitted on the gas market, as they are the direct supplier here, and also of the market with regards to the oil, as Romanian pipeline is directly interested. So we are submitting this.
Thank you. And do you want to reply also to the other question? If you want to say something, or
We believe that we have nothing to submit as of this moment. Thank you.
thank you. So I think we can continue with the third P. And I leave the floor to the applicant.
Okay. So the fourth plea. The
Yes. Yes.
Okay. Yes, sir, Your Excellencies, we submit that the finding in the contested decision as to the refusal of access to the Romanian Pipeline 1, which is imputed to them, is vitiated by errors of law and not fact. The line of argument consists of 8 parts, alleging respectively an error of law in that Article 102 Treaty on Functioning of European Union was applied to a contractual clause that had been agreed bilaterally. An error of law in that an abusive refusal to supply was imputed to Bulgar Gas, even though the latter was merely a user of the Romanian Pipeline 1. Transgaz's failure to forward to the applicant's request for access to the Romanian Pipeline 1, and an inadequate statement of reasons in the contested decision concerning the inclusion in the infringement of a restriction on Overgas gaining access to the Romanian Pipeline 1. Bless you. A lack of evidence of a refusal or restriction on Overgas gaining access to the Romanian Pipeline 1 in 2013, the absence of a refusal to supply Sea Energy Group, the lack of probative value of the reservation of all the capacity on the Romanian Pipeline 1, and the lack of probative value of discussions relating to the renegotiation of the 2005 agreement. So we would like to start with the first part. In our opinion, the contested decision is vitiated by an error of law in that the refusal to provide access to the capacity of the Romanian Pipeline 1 is not the result of unilateral conduct, but stems from a contractual provision that was agreed bilaterally set out in the 2005 agreement. We consider that such a contractual agreement falls outside the scope of Article 102 of the treaty on functioning of European Union. Should we like do like my first part and then them and the second part and then them, because it's a really long plea. So
Yes.
okay, there was.
So I give the floor to for the first part.
Madam President, but have they submitted their first plea yet?
The first
Like
part.
the fourth plea, but just there are like 8 parts in
Yes,
the
I
first
understand.
one.
But if I understand correctly, you have read the points.
Like the
But
whole.
yes,
and
but you
then
have not submitted.
No, I like read the whole 8 points and then I read the first part.
Oh, okay.
And
okay.
I just asked if I should continue
Okay.
with all or we just like
Okay.
first part me, first part you.
I apologize. I understand.
Okay, it's okay.
Okay, thank you. Thank you, Madam President, Your Excellencies. Well, allow me to continue with the remaining fourth plea. I shall firstly address, of course, the first part, the A, alleging an error of law in the application of Article 102 of the TFU, that it is a contractual clause and therefore it is excluded out of this, as the applicants have submitted. Your Excellencies, we submit that the agents of the applicant were trying to hide their abusive conduct under this contractual clause between the Bulgargas and Transgas, because they are stating that as this stems from a bilateral agreement, the agent of the applicant claimed it was not a unilateral conduct and therefore it could not have been inside the scope of Article 102 of the TFEU. However, as we have submitted in our contested decision, during the infringement period, Bulgargas had, under the 2005 agreement, not only reserved all capacity on the Romanian pipeline one, but could also prevent any attempt by Transgas to grant capacity to third parties on the primary market, as we have submitted. Thus, it must be stated that their actions are a clear display of a dominant position, and as they effectively have controlled who could and who could not be connected to the Romanian pipeline. And therefore, their plea that this conduct falls outside of the scope of Article 102 of the TFU is a clearly motivated action and a mistake of law. If the court were to accept this, it would effectively open doors to every country to just create bilateral treaties and avoid application of Article 102. And Your Excellencies, this is something that we, as the agents for the Commission, cannot close our eyes upon. Moreover, it is clear that this is actually part of the anti-competitive strategy of the BEC Group, intended to protect its position on the Bulgarian gas supply markets. So as follows from all that we have submitted, the first part of this plea must be rejected. Thank you, Your Excellencies, and this concludes my plea.
Thank you. So, do you want to follow up with the second part?
Oh, second part, yeah. I thought you were asking about reaction. Yes. So, about second part of our plea, we think that the contested decision is vitiated by an error of law in that it imputes to Bulgargas an abusive refusal to supply on the Romanian pipeline 1, when Bulgargas was neither the owner nor the TCO of the essential facility and was merely a user of it. According to the judgment of 26 November 1998, called Bronner, and of 10 July 1991, called RTE versus Commission, on which the Commission based its analysis in recital 549 of the contested decision and the subsequent case law relating to a refusal to grant access to an essential facility. Abusive conduct can be imputed only to the owner or operator of that facility, in the sense that access to essential facilities has always been intrinsically linked to the ownership and control of the facility or service in question. And since since we are not the owner, we are just a user, this doesn't apply for us.
Thank you. Does the defendant want to follow up?
Yes, Madam President, we would like to follow up with this, of course, claim. Firstly, we submit that the applicants argumented, of course, that a number of previous Commission decisions regarding the refusal to grant access to gas were only addressed to undertakings which were both the owners of the TSO and the relevant infrastructures. And since the Bulgargas claimed it was not the owner, but a mere user of the Romanian pipeline, the court should annul the contested decision in accordance with its previous case law. This is what the applicant has submitted. However, we must emphasize that pursuant to, for example, the General Electric v. the Commission case and others, of course, The Commission is required to carry out an individual appraisal of the circumstances of each case without being bound by its previous decisions concerning other undertakings or other markets at different times. Thus, undertakings are not entitled to call the Commission's findings, the previous ones in question, on the ground that they differ, and that something that we have decided previously does not necessarily constitute a binding law on us as the Commission. Therefore, this is not applicable. But according to the Bronner case, which was also invoked by the agents of the applicants, there are actually three prerequisites which must be met in order for Article 102 of the TFUE to be met, to be breached. First of all, if the refusal of service is likely to eliminate all competition on the part of the person who requested the service in that market. Here we submit that this is clear, since they had effectively controlled who could and who could not be connected to the Romanian Pipeline 1. We submit that this is an elimination of all competition. So the first prerequisite is therefore met. Second prerequisite which must be met is that the service in question is indispensable for carrying on the person's business, in so much as there is no actual or potential substitute of that service. As stems from the fact of the case, Your Excellencies, Romanian Pipeline 1 is and still remains up to this day the only viable solution to process oil and gas, of course, into the country. So we say that it is indispensable for carrying on the person's business. And lastly, the refusal cannot be objectively justified. Here, Your Excellencies, we will submit there was no reason as to why the agents of the applicants rejected or have somehow hindered of course, granting of the access. There was no reasons for them to occupy the whole Romanian pipeline, yet they did it. Therefore, Your Excellencies, we submit that the second part, alleging the judgment in Bronner and of course the case law which I have presented, all of this must be rejected, and this concludes my opinion. Thank you.
Do the applicants want to reply, or do you want to follow?
We would like to follow with the third part. So, about the third part, we have two complaints. First, Transgas's request during the meeting of 24 January 2011 did not constitute a request for access to the Romanian pipeline. And second, that Transgas also did not forward to us requests from third parties for access to the pipeline under Article 17.1 of the 2005 agreement. Transgas never sought Bulgargaz's consent for the granting of access to other network users, and in particular that Transgas did not submit any request for access to the Romanian pipeline 1 to BEH on 24 January 2011. Transgas also failed to forward to us individual requests for access to the Romanian pipeline 1 made by third parties. Can you pronounce this? Yes.
Pursuant.
Sorry. To Article 17.1 of the 2005 agreement.
Thank you. So, would you like to reply to the applicants, or would you like to go on with it?
Madam President, we would like to, of course, reply and continue with our submission simultaneously. So, first of all, Your Excellencies, the agents stated that the meeting of 24th of January 2011 did not constitute a request for access to the Romanian pipeline. However, Your Excellencies, we submit that this is a mistake of fact. It is apparent from the minutes of the meeting of the 24th January 2011 that during that meeting, Romgaz and Transgas disclosed to BEC, the agents of the applicants, an intention to set up a joint venture with two other third-party undertakings in order to build a terminal in Constanta for Overgas, the intervener. With view that the future construction, Transgas also raised with BEC the question of possibly providing part of the unused capacity on the Romanian Pipeline 1. And BEC replied even that all of the capacity had been reserved for Bulgargas. Therefore, we can see that there was indeed a request for access that was denied by the by the agent of the applicant. Therefore, their plea must be again rejected. Thank you.
Thank you. So, would you like to reply to the defendants, or okay, so I give you the floor for the fourth part.
Okay, thank you. We consider that the contested decision does not contain an adequate statement of reasons because it does not clearly indicate whether the examples of restriction on Overgas gaining access to the Romanian Pipeline 1 in 2013, which are set out in section 5.4.4.2 of the decision dealing with the facts, constitute elements of the infringement since those elements are not mentioned either in the operative part of the contested decision or in the description of the allegations relating to Article 534 of the decision. The omission prevents an understanding of the scope of the contested decision. Thank you.
So the defendants has the floor to proceed with the vote.
Thank you, Madam President, Your Excellencies. Well, we'd like to, of course, respond to this. That although the operative part does not specify whether the refusal of access to the Romanian Pipeline 1 alleged against the applicants includes a restriction on Overgas gaining access to the pipeline, the fact remains that the restriction on access, which would result inter alia from delay within the corresponding request, is actually and should be interpreted akin to refusal of access. Thus, the operative part must be interpreted in the light of the relevant grounds of the contested decision and must be deemed to be a refusal of access, Your Excellencies. Thank you, and this concludes the report.
Thank you. So I leave the floor to the applicants for the fifth part or to reply to the defendants.
We would like to continue with the fifth part. So, in our opinion, the Commission has not adduced evidence of a refusal or restriction on Overgas gaining access to the Romanian Pipeline 1 that is attributable to them. We raise 5 complaints alleging, respectively, that the Commission cannot attribute to Bulgargas a rejection of Overgas request made to Transgas for access to the Romanian Pipeline 1. Bulgargas provided Overgas with access to the Romanian Pipeline 1 without delay from its first request. Bulgargas did not delay the signing of the agreement concluded with Overgas on 31st January 2013 for access to that pipeline until it had concluded contracts downstream with its own customers. The Commission incorrectly concluded that the initial 3-month duration of the 2013 pipeline access agreement was insufficient, and the conditions for the extension of that agreement were not uncertain. The request for access to the Romanian Pipeline 1 made by Overgas in 2010 and 2011 were addressed to Transgas, and that therefore the way in which those requests were dealt with cannot be attributed to us. We consider that the Commission incorrectly concluded that Bulgargas had delayed Overgas access to the Romanian Pipeline 1 for 2013. We submit that Bulgargas fully cooperated with Overgas as soon as it received the letter's request for access of 23rd November 2012, and that it handled the request diligently despite the absence of rules governing the trade of secondary capacity on the Romanian Pipeline 1 and the fact that the 2005 agreement did not. In our opinion, the Commission has failed to establish that Bulgargas delayed the signing of the 2013 pipeline access agreement until it had concluded gas supply contracts with its own customers. It is apparent from the contest by relying exclusively on the allegation in Overgas' statement of 3rd October 2013, the Commission merely assumed that the fact that Bulgargas had concluded gas supply contract with its customers before concluding the 2013 pipeline access agreement could be explained only by Bulgargas' anti-competitive conduct. We dispute Overgas' allegations by relying on the chronology of the facts. We argue that Overgas did not contact Bulgargas regarding access to the Romanian Pipeline 1 before 23rd November 2012. That is, 1 to 2 months after Bulgargas had, according to Overgas' statement of 3rd October 2013, customers had already been concluded before Overgas' access request was submitted. Until 23rd November 2012, Bulgargas could not have known that Overgas would submit a request for access to the Romanian Pipeline 1 to it. If Overgas had submitted its request earlier, Bulgargas would have had the possibility of granting it access before signing contracts with its customers for 2013. We also claim that Bulgargas signed the 2013 pipeline access agreement shortly after receiving Overgas's request and gave the contract retroactive effect from 1st January 2013. The contracts concluded between Bulgargas and its customers for 2013 were short-term contracts providing for a right of unilateral termination by the customers, subject to 3 months' notice in the event that those customers changed their gas supplier. Those contractual provisions therefore enabled Overgas from January 2013 to persuade Bulgargas's customers to change supplier and enter into contract with Overgas. And in February 2013, one of the Bulgargas's customers thus became a customer of Overgas. We dispute the Commission's conclusion in recital 312 and 543 of the contested decision that the initial 3-month duration set out in the agreement for Overgas's access to the Romanian Pipeline 1 for 2013 was insufficient. We consider that the initial period does not constitute wrongful conduct on their part. We dispute the finding in the contested decision that the extension of the 2013 pipeline access agreement was subject to uncertain conditions. In that regard, the Commission's position that the letter sent by Bulgargas to Overgas on 25 February 2013 constituted an interruption in the supply of services to Overgas and adversely affected the latter's operations on the Bulgarian wholesale supply market is incorrect. Thank you.
Thank you. So the defendants can comply or wrong with their
Madam President, we would, of course, like to react and go on with our submissions. Well, first of all, we will very briefly go through these complaints that the agents of the applicants have submitted. To begin with the first complaint, that the Commission cannot attribute to Bulgargas a rejection of a Bulgargas request made to Transgas for access to the Romanian pipeline. On this point, as we have pointed out numerous times during this plea, and it stems from the 2005 agreement on the Romanian Pipeline 1, everything was reserved for the exclusive use of Bulgargas and Transgas, and they could not offer the capacity to that pipeline to third parties without obtaining first the consent. This is clear, Your Excellency. Therefore, this rejection must be deemed to be attributable to Bulgargas, and it was the one who is effectively, basically deciding on who stays and who does not stay on that. Therefore, we submit that the first complaint must be rejected. What it takes to the second and third complaint, Your Excellencies, the agents of the applicants submit that Bulgargas provided Overgas with access to the Romanian Pipeline 1 without delay from the time of its request. However, as we have submitted, Your Excellencies, Overgas was granted access only after Bulgargas had concluded contracts for the whole 2013 year with all the Bulgarian customers except Overgas. And despite the high levels of unused capacity in Romanian Pipeline 1, the access that was granted to Overgas covered only a short period of time. Initially 3 months, of course, and then 9 months. But the conditions, Your Excellencies, even for a possible extension of the 2013 pipeline access were uncertain, as we will elaborate on later, and therefore the second and third complaint must be rejected. Your Excellencies, proceeding to the fourth complaint, alleging that the Commission incorrectly concluded that the initial 3-month duration of the 2013 pipeline access agreement with Overgas was insufficient, we submit that Overgas complained about the short duration of the 2013 pipeline access from medium or long-term contracts with its gas supplier upstream and with its customers in Bulgaria downstream, even though a high proportion of the capacity of the Romanian pipeline was unused. And 3 months, Your Excellencies, is simply not enough. It is clear as possible. And this is, Your Excellencies, again, a violation of Article 102 of the TFEU. Your Excellencies, proceeding to the last fifth complaint, alleging that the condition for extending the 2013 pipeline access agreement were not certain. In the contested decision, Your Excellencies, we have found that the conditions for the extension of the pipeline access agreement, concluded for an initial period of 3 months with an automatic renewal clause, remain unclear. We would state that the letter of the 25th February 2013 cancelling the automatic extension of the contract had adversely affected Overgas activity on the Bulgarian wholesale market because it could no longer be sure that its contract would actually be extended until the end of 2013. Overgas informed us, the Commission, that Bulgargas announced the termination of the 2013 pipeline access agreement less than 1 month after the agreement was signed, showing that even the existing agreements were by no means certain, and that Overgas was entirely dependent on Bulgargas goodwill to give it access to the Romanian pipeline one. And if this, Your Excellencies, is not sufficient evidence that there was indeed an abuse of dominant position, then we submit that we do not know what is. Thank you, and this submits and concludes my plea.
Thank you. So the applicants can go on with the fifth part or reply to the defendants.
One second, please. Okay. So we will continue with another part. We claim that in recital 534C of the contested decision, the Commission incorrectly classified Bulgargas' failure to reply to C Energy Group's letter of 26 September 2013 as a refusal to supply, which prevented C Energy Group from entering the Bulgarian gas supply markets. According to us, by that letter, C Energy Group, which was only an electricity trader, merely requested information on the conditions for obtaining access to the Romanian pipeline one, never followed up on that request. Moreover, when C Energy Group sent that letter, Overgas already had access to the Romanian pipeline one as a result of the 2013 pipeline access agreement. Thank you.
Thank you. So I leave the floor to the defendants if they want to take a reply or go on with the other person.
Thank you, Madam President. Well, we will, of course, react to the sixth part, alleging that there was no refusal to supply the C Energy Group. Your Excellencies, in 2013, the C Energy Group attempted to obtain access to the Romanian Transit Pipeline 1. However, in September 2013, C Energy Group submitted a request to Bulgargas regarding access to this Romanian pipeline. It requested Bulgargas to confirm the possibility to be granted access to the pipeline. C Energy also provided a schedule with the gas quantities it was planning to transport in 2014. But Bulgargas, Your Excellencies, never replied to C Energy Group. According to Bulgargas, this was around the same times when it was discussing with Transgas the amendment of the 2005 commercial agreement. Thus, as stated by Bulgargas, instead of contacting the undertaker and providing information about the access to the Romanian transit pipeline line, it remained silent. But with lack of access to the only import pipeline bringing gas to Bulgaria, C Energy Group was unable to enter the gas supply markets in Bulgaria, and therefore there was a refusal to supply C Energy Group, Your Excellencies. Thank you, and this concludes my plea.
Thank you. So do the applicants want to reply? Or?
No, we would like to continue with
Okay, so
another
you
part.
can go on.
So we think that the probative value of the reservation for Bulgargas of the entire capacity of the Romanian pipeline one in order to establish a refusal to supply when no individual request for access to that pipeline was refused. Thank you.
Thank you. So I leave the floor to the defendants if they want to take a reply or go.
Thank you. This time we would like to reply only. And we submit that Commission has abducted firm, precise, and consistent evidence within the meaning of the case law, which was, of course, referred to in the Bronan case, to establish to the requisite legal standard that the conduct which was alleged against Bulgargas concerning access to the Romanian pipeline one constitute a refusal of access capable of falling within the scope of Article 102 of the TFEU, and therefore this first sub-plea must be rejected, Your Excellencies. Thank you.
Thank you. So do the applicants want to go on with the seventh part?
Yes, we would like to go on with our seventh point. We dispute the eighth point of our argument. We would like to dispute the probative value of the discussion relating to the renegotiation of 2005 agreement. In that regard, the contested decision incorrectly establishes that those intergovernmental discussions constituted a refusal to grant access to the Romanian pipeline and that Bulgargas had not acted constructively during the negotiations regarding to the 2005 agreement. In that regard, they put forward 3 complaints. The 3 complaints are as follows: the intergovernmental nature of the renegotiation of the 2005 agreement, the constructive nature of their conduct during their negotiations, the fact that they are now responsible for the duration of those negotiations, we submit that the discussion of the renovation of the 2005 agreement were initiated and took place in the intergovernmental level, involving the governmental and regulatory authorities to the Republic of Bulgaria and Romania. Those discussions cannot therefore be imputed to Bulgargas. The applicants rely on the three elements as follows. The fact that 2005 agreements stem from the 2003 intergovernmental agreements as follows. The fact that 2005 agreements stem from the 2003 intergovernmental agreement. The fact that the purpose of the renegotiation of the 2005 agreement was to resolve the concerns raised in the infringement proceedings against Romania. The central nature of the gas supply in Bulgaria and Bulgargas' role as a public supplier in the renegotiation of the 2005 agreement. We submit that the 2005 agreement was signed in accordance with the 2003 intergovernmental agreement, with the result that the renegotiation of the 2005 agreement required the involvement of the governmental authorities of the Republic of Bulgaria and Romania. We submit next that it was on the initiative of the Romanian governmental authorities that the discussions concerning the renegotiations of the 2005 agreement began in June 2011, and that the trigger for those discussions was the initiation by the Commission in 2009 of the infringement proceedings against Romania. We submit that in the context of those proceedings, the Commission found that Transgas has failed to fulfill its obligations as TSO of the Romanian Pipeline 1 under European Union law, and that the Commission required in particular that Romania amend the 2005 agreement. In the context of the renegotiation of the 2005 agreement, Bulgargas acted as a public supplier of last resort entrusted with a service of general economic interest and, as such, was required to ensure gas supply throughout Bulgaria. According to us, the proposal of Transgas's guarantee of a minimal capacity of 3 to 4 billion cubic meters out of the total capacity of 7.4 billion cubic meters per year on the Romanian pipeline. One met
That's one. Pipeline one.
Pipeline
Pipeline
1 met Bulgargas's public supply obligations. During the discussions on the renegotiation of the 2005 agreement, Bulgargas acted constructively and agreed to amend the 2005 agreement. During the infringement period, Bulgaria depended on a single source to guarantee its gas supplies, namely the gas from Russia, supplied during that period by Gazprom and its subsidiary Overgas, and dependent on a single transit route, namely the Romanian Pipeline 1. During the preparation for the Republic of Bulgaria's accession of the European Union, and in particular during the period between 1991 and 1997, Bulgargas obtained its gas supplies from Russia under supply contracts concluding for short periods, namely for periods of 3 months to a year. They submit, however, that from the time when the Republic of Bulgaria began to draw closer to the European Union, the gas supply contracts concluded by Bulgargas with its supplier Gazprom, included with the latter subsidiaries, namely the WI, EE, and Overgas, together the upstream supply contracts with Gazprom, evolved significantly. When Bulgargas took part in discussions on the renegotiations of the 2005 agreement, it acted in its capacity as a public supplier of last resort, entrusted with a service of general economic interest, and as such obliged to ensure a gas supply for the whole of Bulgaria. Thus, the views which it expressed during the negotiations and conditions as such, conditions which in the contested decision the Commission accused it of imposing on Transgas, mainly concerned the security of gas supply in that country. Consequently, Bulgargas cannot be held responsible for those discussions. We claim that the Bulgarian side requested that prior to the amendment of the 2005 agreement, Transgas should draw up a methodology for the establishment of the new transport tariff and the methodology for capacity allocation on the Romanian Pipeline 1. Together, the methodologies on the basis of which Bulgargas would be able to purchase capacity outside the agreement once the latter was terminated or amended. They rely in that regard on the latter which the Bulgarian regulation sent to Romanian regulator on 16 January 2014. They consider that the request would be to be all the more legitimate since, in the context of infringement proceedings against Romania, the Commission specifically criticized that member state for the lack of rules on that subject. We consider that the proposal guarantee of a minimum capacity on the Romanian pipeline 1 for Bulgargas was justified in order to guarantee security of gas supply in Bulgaria and to enable it to meet its statutory obligations in that regard as a public supplier entrusted with a service of general economic interest. We consider that it was legitimate for them to request the fixed annual fee stipulated in the 2005 agreement be amended in order to reflect the reduced capacity level that will be available to Bulgargas in the Romanian Pipeline 1. In our opinion, the length of the renegotiation of 2005 agreement is not attributable to the Bulgargas. It is the Romanian party which is responsible for it, inter alia, because during the renegotiation of that agreement, that party was responsible for submitting to the Commission the proposal for the guarantee of a reserved minimum capacity. Thank you, judges, and thank you.
Thank you. So now I give the floor to the defendants.
Thank you, Your Excellencies. We would like to respond to what the agent of applicant just said. We believe that this part of applicant's pleading is tied to the allegations that the Commission failed to assess whether Bulgargas held a dominant position in the context of the discussion with Transgas, and it's related to renegotiation of the 2005 agreement. In those circumstances, the applicants cannot validly complain that the Commission failed to assess whether the Bulgargas enjoyed a dominant position vis-a-vis, because the Transgas, in the context of this discussion of the renegotiation of the 2005 agreement, which means that the third complaint must be rejected, along with the statement of the agents of applicant regarding the methodology. As regards of the capacity allocations methodology, it did not require Transgas to withdraw any existing capacity that Bulgargas had not used, but it only obliged, and I would like to emphasize the word obliged, Transgas to sell the available capacity on that pipeline. Therefore, since the agreement remained in force throughout the infringement period, it is clear that there was no available capacity that Transgas would have sold to the third-party undertakings on the pipeline at the time, and therefore, Your Excellencies, this part of the pleading must be rejected. Thank you.
Thank you. So now I give the floor for the conclusions to the applicants.
What conclusion?
If you want like to conclude, if you want to do a resume and then conclude. If you want to add something.
Okay, no, we don't want to add anything.
Okay, so can we have like 5 minutes of break?
Yeah, you can break it, you can prepare the question, then you
prepare the
can
questions.
ask.
And
Yeah.
after, do they have to do also the suppliers or they can go on with the last one? Last one.
Then they can continue with what they prepared next.
That's the last plea.
Yeah.
That's the last piece.
Okay, okay. Because yes, in the documents there were also other sub-plies, but they were the parts in red. So
Yeah,
we
yeah,
don't
yeah.
have
That
to
was
do that.
that part,
Okay.
which was just for your information,
Okay,
just for
okay.
the context.
Perfect. Okay. Quindi, okay.
Ciao.
Okay, so erano le liste
Again, the same introduction.
Okay, so we now continue with the audition. So now we want to do some questions.
Not audition.
How do you say not audition? How do you say like process?
Proceeding.
Proceeding.
Okay, proceeding. So now we would like to do a question to the defendants and a question to the applicants. So I leave the floor to my colleague.
The defendants mentioned that there were no real reason to occupy the Romanian pipeline 1, and the applicants said that they are the mentioned license. So, apart of protecting market competition, why the defendants thinks that the license mentioned isn't a sufficient reason to use exclusively the pipeline?
Your Excellency, thank you for your question. Well, as we have stated, we do not dispute the fact that they have the license and it may be lawful under the Bulgarian national law. However, we have also another system, the supranational system, the European Union law, and it stems from Article 102 of the TFEU that there is a abusive conduct of the dominant position, and which is prohibited. And we are stating here that this is what was violated. Not the Bulgarian law, of course, per se, but the European law was violated. They could have had any reasons which could be valid under the Bulgarian law to have the exclusive right to occupy the whole pipeline, of course. But we submit that this conduct is actually in violation, because if they have the whole pipeline and they do not use the whole pipeline as such, but still reserve it for themselves, it is nothing else but an abusive conduct of the dominant position. Thank you.
Thank you. Thank you. So I leave the floor to my colleague.
Yeah, the defendant provided us with some interesting information. Why Bulgargas never replied to see electric group? This question is for the applicants.
Thank you for the question. We will answer it next year.
Okay, thank you.
Thank you,
So
Rainy.
I think we can conclude the first part of this proceeding,
And we will continue tomorrow.
and we will continue tomorrow.
Okay, thank you.
Thank you.
And that's it.
Thank you all.
So what will be tomorrow? I said it to some of you, but not all of you. They will start with the decisions about the police which we were discussing today. Then you will talk about, so first you will respond to questions, which you said that you will respond tomorrow. So that's what we will then start with. Don't forget about it. They still need to answer you something. And then we will go to the plea number 1. And then, like today, the break for questions, you will prepare questions, you will answer. You will then prepare the decision about that. And then you will have time for final judgment. And then there will be a lunch break. After lunch break, there will be judgment and a press conference.
Okay.
Thank you.
Thank
And
you.
you are free today. Tomorrow we will start